Good evening and welcome to Columbia Law School. My name is Michael Gerrard. I'm a professor here at Columbia, and I direct the Sabin Center for Climate Change Law and also teach environmental law and energy law here at Columbia. This evening's program is being co-sponsored by the Sabin Center and by the Earth Institute of Columbia University. Before I get to the substance of tonight's programs, I have a few administrative items to get out of the way. A week from tomorrow, on Thursday, June 2nd, we're hosting in this room an all-day conference, the Key Environmental Issues in EPA Region 2 conference, which we hold every other year, co-sponsored by EPA Region 2, which covers New York, New Jersey, Puerto Rico, and the Virgin Islands, and the American, New York State, New York City, and New Jersey Bar Associations. 6 hours of CLE credit are provided. Registration is required. Details are on the flyer that is on the table in the back and on the Sabin Center website. This evening's program is being videotaped. The video will be posted on our website. So please be aware that audience questions as well as the speaker's remarks are going to be recorded. And please be sure to turn off or silence your cell phone now. Before I introduce our panel, I'm going to give a little background on why we are here this evening. The Securities Act of 1933 and the Securities and Exchange Act of 1934 govern the registration and sale of securities and related disclosure requirements and require publicly traded companies to report certain information to the public. These laws are enforced by the Securities and Exchange Commission. The SEC's Regulation SK furthers these disclosure goals. Regulation SK requires, among other things, certain kinds of environmental disclosures. There was a lot of uncertainty about what, if any, disclosures were required relating to climate change. And in 2007, the group Ceres led a coalition that included the New York Attorney General's office that filed a petition with the SEC seeking formal guidance on this issue. In 2010, the SEC issued an interpretive guidance on disclosure requirements specifically related to climate change. The guidance highlighted 4 issues that may require disclosure: existing and pending legislation and regulations in the U.S., international climate change accords and agreements, the indirect consequences of climate change regulation and resulting business trends, such as decreased consumer demand for carbon-intensive goods or the impact on the company's reputation, and fourth, the physical consequences of climate change as it could affect the company. Not all have been happy with the performance of many companies in making these disclosures or with the vigor with which the SEC has enforced them. However, the SEC is not the only securities regulator. Most of the 50 states have their own securities laws called blue sky laws. New York's blue sky law, which is called the Martin Act, is one of the most powerful in the country. It's enforced by the New York Attorney General. Last November, it was announced that the New York Attorney General, Eric Schneiderman, had been investigating Peabody Energy over whether it properly disclosed financial risks related to climate change, and that a settlement had been reached in which Peabody agreed to correct certain past disclosures and strengthen its future disclosures. Last November as well, it was revealed that the New York Attorney General had launched an investigation into the climate disclosures of ExxonMobil, starting with demands for documents. We will hear more about the status of that investigation this evening. On March 29, Mr. Schneiderman was joined by the Attorneys General of Vermont, Maryland, Massachusetts, Virginia, Connecticut, and the Virgin Islands, and representatives of the Attorneys General of several other states, and former Vice President Al Gore. They pledged to continue working together on legal actions related to climate change risk. Massachusetts and the Virgin Islands also announced that they are starting their own investigations of ExxonMobil. Then things really heated up. The Virgin Islands subpoenaed not only ExxonMobil, but also the Competitive Enterprise Institute, a nonprofit group that opposes climate regulation, whereupon ExxonMobil instituted a lawsuit in state court in Texas against the Virgin Islands Attorney General and his outside counsel, asking the court to declare that the subpoena to ExxonMobil violates the company's rights under the First, Fourth, Fifth, and 14th Amendments to the U.S. Constitution and the Texas Constitution. The parties are now litigating over whether that case should be in state court or federal court. The Virgin Islands Attorney General later said he was withdrawing his subpoena to the Competitive Enterprise Institute, but according to the press, that group is asking the Superior Court of the District of Columbia to assess attorney's fees and other sanctions against the Attorney General for launching an investigation that it said violated its First Amendment rights. In a further escalation of the issue, last week on May 18, the House Committee on Science, Space, and Technology, chaired by Representative Lamar Smith of Texas, asked Mr. Schneiderman to produce documents concerning its investigations of ExxonMobil and others, stating that it was concerned that these investigations amounted to an abuse of prosecutorial discretion. In response, Mr. Schneiderman's spokesman said, quote, "It is remarkable that a do-nothing Congress that has refused to take any action on climate change is now attempting to disrupt this important investigation into potential corporate malfeasance," close quote. This fact pattern of a congressional committee conducting an investigation of an ongoing state investigation seeking to see whether there are violations of state law strikes me as an excellent fact pattern for the final exam and with the constitutional law classes that are taught in this room. Today was the shareholders meetings of both Exxon and Chevron, and the bulletin that ran on the Wall Street Journal a couple of hours ago was headlined, "Exxon and Chevron shareholders narrowly reject climate change stress tests." And the article begins, "Shareholders at ExxonMobil and Chevron narrowly voted down resolutions calling for stress tests to determine the risks that efforts to curb climate change pose to their businesses. Despite the defeat, the proposals drew more support than any contested climate-related votes in the history of the two biggest U.S. oil and gas companies. Preliminary results showed 41% from Chevron investors that cast ballots and 38% at Exxon, an indication that more mainstream investors are starting to take more seriously the threat of a global weaning from fossil fuels. So hopefully that sets the stage for tonight's discussion, which turns out to be even more timely than we thought it would be when we first scheduled it a few months ago. I'll introduce our panelists. I'll then ask each of them a series of questions. Then I'll open it up to questions from the floor, so please hold your questions until then. We will adjourn at 8:30. Lemuel Srolovic is the Bureau Chief of the Environmental Protection Bureau in the Office of New York Attorney General Eric Schneiderman, and in that role has played a leading role in the investigation of ExxonMobil. Before joining the Attorney General's office, he was a partner in the law firm of Sive, Paget, and Rizal, and before that he practiced with Weitz and Luxembourg. Mary Shapiro, a former chair of the Securities and Exchange Commission, had planned to be here this evening. However, at the last minute, she was called to a meeting in China, and she is on an airplane going there right now. But we are pleased to have Daniel Firger here in her place. Daniel is a member of the Environment Program at Bloomberg Philanthropies, where he helps manage the Foundation's Energy, Climate Change, and Sustainable Finance Program. And he advises Michael Bloomberg in his role as chair of the Financial Stability Board's Task Force on Climate-Related Financial Disclosures. He'll be telling you about the origins and goals of that task force. He was formerly a fellow here at the Sabin Center for Climate Change Law. Christopher Davis is Senior Program Director and leads the investor program at Ceres, a nonprofit organization focused on sustainable business and investment strategies and practices. He's Chief of Staff of the 120-member Investor Network on Climate Change. Prior to joining Ceres in 2010, he spent almost 30 years practicing environmental law, ultimately chairing the environmental practice at the law firm of Goodwin Procter. Prior to his legal career, he worked as an environmental engineer. And finally, Merritt Fox is the Michael E. Patterson Professor of Law and NASDAQ Professor of Law and Economics of Capital Markets here at Columbia Law School. He's co-director of the Center for Law and Economic Studies and co-director of the program in the Law and Economics of Capital Markets. He teaches and writes about corporate and securities law and economics and international finance. Before coming to Columbia in 2003, he taught at the University of Michigan Law School, and before that he practiced here in New York at Cleary, Gottlieb, Steen, and Hamilton. So with no further ado, we'll start with the questions, and I'll start with my questions of Lem Srolovic. Your office reached a settlement agreement with Peabody Energy. Can you tell us what that agreement was about and what principles did it establish?
So thank you, Columbia, for hosting this discussion on an important and timely topic. And thank you, Michael, for inviting me to participate. I want to start answering that question by putting the Peabody Energy settlement agreement in just a little bit of context. Based on the overwhelming weight of the evidence, Attorney General Schneiderman believes that climate change is a defining issue of our time and that climate change presents a clear and present danger to New York's environment, public health, and our economy. We already are seeing consequences of climate change right here in New York. In New York City, sea level is about 1 foot higher than it was 100 years ago, and it continues to rise. Rising sea level makes coastal storms like Hurricane Sandy even more devastating. Almost 2 million utility customers were out of power after Sandy, many for weeks. Hospitals were shut down. If you were here, you remember those images. Patients were evacuated, displaced. Sewage treatment plants were knocked out. Raw or partially treated septic washed into our waterways, and extended power outages and other infrastructure failures in the New York area alone were estimated to have caused between $30 and $50 billion in lost economic activity. I'll give you one other quick example. On a seemingly normal day in August of 2014, a weather front stalled out over Long Island, resulting in New York's heaviest downpour on record. That storm dumped 13.5 inches of rain, almost an entire summer's worth of rain for that area in a matter of hours. Stormwater drainage was overwhelmed. Families had to evacuate their homes. Drivers abandoned their vehicles to escape rapidly rising floodwater. Thousands of homes and businesses lost power. Many homes sustained flood damage, many of which reports indicated were not in flood-prone areas generally and did not have flood insurance. So initial damage estimates from that one storm exceeded 30 million. And that was just one local storm on Long Island. Now, I'm not saying that the Long Island deluge was caused by climate change, but in 2014, our office released a report that documented the dramatic increases in the frequency and intensity of extreme rainfall events across New York State, and found that the best available scientific projections tell us that the frequency of extreme precipitation events will increase in the future. Now, why do I say that about Peabody? Well, it's clear that the power of climate change, its power to disrupt our weather, our power supply, our transportation, and other infrastructure also has the power to disrupt markets. And perhaps nowhere is that more so than in our energy markets, and particularly fossil fuel markets. So getting to Peabody. Before it recently went into bankruptcy, Peabody was the largest publicly traded coal company in the world. It also appeared to be pursuing a business plan that seemingly was oblivious to economic risks to the company driven by climate change. In 2013, our office reviewed the company's disclosures to investors and the public about its businesses and its prospect for the future, and had concerns about whether certain disclosures the company was making to investors and the public regarding financial risks were true and accurate. Then in November of last year, our office found that the company violated New York laws prohibiting false and misleading conduct in those statements in two respects. First, Peabody repeatedly claimed in its securities filings that it was unable to predict the financial impact that potential regulation of greenhouse gas emissions would have on its business. But the company and its consultants did in fact make such projections regarding the impact of potential laws and regulations, and actually projected severe financial impacts from certain potential regulations, which the company did not disclose to the public. And let me give you two quick examples. In March 2013, Peabody projected that if a specific regulatory action scenario for existing power plants and future electricity generation would be implemented in the United States, in 2025, that policy would reduce the dollar value of sales of coal from the southern Powder River Basin in the United States by approximately 38%, and the Illinois Basin by 33%. Both of those basins are areas where Peabody has a very large market share. Another illustration is in March of 2014. Peabody hired an outside consulting firm which ran an analysis that projected that enacting a $20 per ton carbon cost in the United States would reduce the demand for coal as a fuel resource for electric power generation in 2020 by between 38 and 53% compared to 2013 levels. The second problem that our office found was that Peabody made misleading statements regarding the future demand for coal. And it did so by cherry-picking the most favorable hypothetical scenario for future coal demand that was developed by the International Energy Agency, and presented that scenario in its disclosures as the authoritative international agency's call on the future of coal. But in fact, that scenario was merely the IEA's business as usual scenario, and not the one that the agency considered to be its central scenario, which was significantly less favorable to coal demand. So as part of the agreement concluding that investigation, Peabody filed revised disclosures with the SEC and committed to accurately and objectively represent those topics in the company's future disclosures. So what principles did that agreement establish? I think perhaps the most important thing is that economic risk driven by climate change is an important element of a fossil fuel company's valuation. That's why full and fair reporting is so important to investors and to our economy.
Thank you. Let's now move to the ExxonMobil investigation. We know that information demands have been given by your office to Exxon, but they haven't been, their contents have not been disclosed. Can you tell us where that stands? Is Exxon producing documents? Have there been any judicial proceedings? What's going on now?
So our office did submit a subpoena to Exxon back in November of 2015. There have not been judicial proceedings regarding that subpoena, and the company has been producing documents and cooperating with that investigation.
Okay. Could you address what are the laws that underlie this investigation and what powers they give the Attorney General and what types of relief are available under those laws?
So in New York, our laws protecting investors, you mentioned them in your introduction, commonly known as the Martin Act, which is an element of our general business law. Other provisions of New York statutes in the executive law and our consumer protection laws all vest power in the New York Attorney General to conduct investigations of potential conduct in violation of those laws and to seek a range of relief based on the facts and circumstances of the matter in court, including injunctive and monetary relief. Most of you probably are lawyers or law students, but injunctive relief is basically an order from a court that requires a company to either do something affirmatively or not do something. And available monetary relief under New York laws includes penalties, damages, restitution, and disgorgement of ill-gotten gain. Just emphasize those are, general powers and remedies provided under the law in respect to any particular ongoing matter. We follow the facts and don't prejudge where that will end.
Will it stop with Exxon? Are there other companies or sectors that you're looking at?
Well, again, I think it's too early to kind of speculate on that, but clearly our securities, consumer, and general business fraud laws and conduct in New York in that area are issues that we've been looking at very closely in the fossil fuel industry as well as in other industries, and we will continue to do so.
Some critics of your investigation have said that it's contrary to the First Amendment and that it inhibits free scientific inquiry and debate. What's your response to that?
Well, I think first, the Peabody investigation was not about enforcing climate change orthodoxy, as has been claimed, whatever that might be. And the Exxon investigation is not about that either. The facts of climate change include some facts that we know through science, and what a company knows often is relevant to whether claims made in a commercial context are false or misleading. I think the second point is that the First Amendment doesn't give a company a right to commit fraud, and it's not a defense to fraud. Our investigation in this area are about compliance with our laws that protect our free markets from dishonest statements, not public debate about climate change.
The final question I have for you right now is, what sorts of issues are you concerned with regarding disclosures in the climate change area? And are you looking for compliance with the SEC's regulation SK, or with something different from that?
The focus of our state-level investigations in New York is whether statements made by companies in a commercial context are false or are misleading. That's the metric we apply, and that's the standard.
Okay, thank you. I'm now going to turn to Daniel Firger. You're an advisor to Michael Bloomberg in his role as chair of the task force on climate-related financial disclosures. And could you tell us how that task force was formed and what its mission is and where its work now stands?
Sure. Thank you, Professor Gerrard, and thanks, Columbia, for having me. First, let me say I'm clearly not a former commissioner of the Securities and Exchange Commission. I'm also keenly aware of the fact that I'm not a woman, and so I've tilted the balance of our panel to an all-male panel, and for that I apologize. But I am happy to be here and happy to try to fill in for Mary Shapiro as best I can in discussing some of the origin story behind the Task Force on Climate-Related Financial Disclosures. I am not going to opine on the financial crisis of 2008, 2009, other than to say the G20 created an entity called the Financial Stability Board, and the Financial Stability Board created something called the Enhanced Disclosure Task Force to look at, my best understanding is, long tail, fat tail risk in the financial system that would have the effect of destabilizing capital markets globally. That Enhanced Disclosure Task Force conducted a set of very detailed analyses and was made up, I should say, of private sector, largely banks and financial intermediaries, and then issued a set of recommendations to the Financial Stability Board, I believe in 2010, which to some degree formed some of the basis for European and U.S. Law, including the Dodd-Frank Act. I would defer to Professor Fox on some of the specifics. In recent years, in part thanks to the great work of Ceres and a number of other advocacy organizations, and also I think in part due to the fact that the impacts of climate change are becoming more noticeable in certain sectors of the economy at a minimum, the Financial Stability Board has started at the request of the G20 to examine whether climate risk as a category of risks, and there are multiple within the broad bucket of climate change, could potentially destabilize global capital markets or the financial system in various ways. And I wouldn't necessarily draw analogies between the mortgage-backed securities market in the United States and climate change, other than to say there are unappreciated risks in the financial system that the FSB was constituted to grapple with. And so in 2015, at the request of the G20, the FSB, under the leadership of Bank of England Chairman Mark Carney, who also chairs the FSB, began to examine and do a set of public and private sector stakeholder engagements to examine the issue of climate change broadly. And at the end of last year, on December 4th, at the COP21 Paris Climate Summit, the FSB and Mark Carney specifically announced the creation of a task force and the fact that Michael Bloomberg would chair it. The remit of the task force is largely twofold. To promote more effective climate-related disclosures that, one, will support informed investment, credit, and insurance on underwriting decisions about reporting companies, and two, to enable a variety of stakeholders to understand the concentrations of carbon-related assets in the financial sector and the financial system's exposure to climate-related risk, broadly speaking. That's a pretty broad and somewhat ill-defined mandate, and it was explicitly articulated to us that a lot of the work of the task force would need to be a scoping and narrowing exercise in terms of understanding the state of play in the financial and capital markets disclosure context and the climate and sustainability related disclosure ecosystem more broadly speaking. And that extends far beyond just the securities regulation context that we're somewhat here to talk about tonight. The chairman of the Bank of England identified close to 400 different climate-related and sustainability-related disclosure regimes globally that are either binding and regulatorily derived or derived from voluntary codes of conduct and standards. That is a proliferation that probably is not helpful to an asset owner, an asset manager, a portfolio manager, someone who's trying to understand where fat tail climate-related risks are embedded in a portfolio. And so much of the work of the task force between December 4th, when it was constituted, and now has been a stock-taking exercise to understand what is the current state of play, what are common principles by which a set of voluntary guidelines can be derived, and basically going from scoping in sort of December 2015 through April, May 2016 to writing and refining a set of recommendations, which again will be voluntary in nature. That is largely what the TCFD, like we like to call it, is doing basically between now and the end of the year. I'll just say a couple more words about scope. Governor Carney gave a relatively well-received and widely retweeted speech at Lloyd's of London in the fall of last year, in which he identified 3 broad categories of climate risk around which he thought the task force should organize its thinking. Those are, I wouldn't say in order of priority, but maybe from most immediate and direct to most attenuated, the physical impacts of climate change, and that's things like sea level rise, water availability. If you are a power plant operator and own a fleet of coal, electricity generating units that burn coal, you need a lot of fresh water in order to operate those plants, and in the future there may be less of that available. So the physical impacts of climate change are one dimension along which we are meant to sort of be thinking about, again, systemic risk in the capital markets, broadly speaking. The second is very much what the New York Attorney General's office is spending time thinking about, and that's liability risk. There are any number of theories by which any number of actors, corporate or otherwise, could be in the future held liable for fraud or damage related to impacts in various ways on climate change related issues. And there are lots of probably unrealized risks in various investors' portfolios out in the world, and understanding to some degree where those risks reside, or at least what the order of magnitude might be, is something that the governor, Mark Carney, was quite eager to have us look into. Happy to talk more about that, but one very obvious example, just recent in the news, it's not climate related, but is the Volkswagen scandal. And anyone who owned Volkswagen stock probably was not expecting to have the company have to deal with those types of penalties, or at least the threat of that kind of fine in the U.S. regulatory context. The third and the most, I would say, the least well-defined kind of risk that we're grappling with is what various folks have called transition risk. And that's where we, I think, especially after Paris at the end of last year, recognized the transition from a high carbon, fossil fuels do not have a implicit or explicit cost in terms of carbon emissions economy globally, to a low carbon 1.5 degree or 2 degree mid-century growth trajectory for the world economy will yield a set of disruptions that are far from understood from where we sit today in 2016. And there are companies that will stand to gain and many that may stand to lose, depending on how that transition is managed at the asset level, at the corporate sort of strategy and business development sort of level, and at the sector, industry, asset portfolio level as well. And so understanding how to disentangle those sets of risks and have a set of uniform, consistent, clearly defined guidance, again, voluntary in nature for now from the TCFD, is what the work between now and the end of the year will entail. Our job, and Mike Bloomberg's job as chair, is to deliver a report to the Financial Stability Board, which will deliver that report or publicize that report in the context of the G20, which originally was the entity that requested the FSB undertake this exercise. And I will just point out, in a realpolitik kind of way, China is currently the chair of the G20. Next year in 2017, Germany will take up the chairmanship, And it is no secret that the Germans are eager to understand this issue and to elucidate a set of principles around climate, a 1.5 or 2 degree scenario, and financial capital markets. And so the work will formally end with the publication of our report at the end of the year, but there is no doubt that this will be the next step in a very lengthy process for the financial sector to really grapple with what's at stake when it comes to transforming the world economy to run on a less high carbon source of energy.
Thank you. About a month ago, on April 22nd, the SEC issued a concept release which was seeking public comment on modernizing certain business and financial disclosure requirements in its regulations, SK, and they specifically included climate change issues among the different issues that were listed. There is a comment deadline for that of July 21st. What do you expect will result from this exercise with respect to climate change?
That's a great question, and one that Mary Shapiro would be intimately familiar with, and unfortunately I'm not quite as familiar. I would say two things, just sort of threshold observations. The first, just to point out again, the 20 governments that are members of the G20 and the central bankers who sit on the Financial Stability Board have asked us explicitly not to create a set of guidelines that will be incorporated by reference by national securities regulators, et cetera. This is a voluntary exercise in order to develop a set of consistent and decision-useful standards for the financial system. So the TCFD's recommendations are not going to supplant or otherwise even inform, unless the SEC wants them to, the future direction of SEC regulation on climate change. That said, I think I'm happy to kind of think a bit collectively with my other panelists about what is useful about the way the SEC has gone about requesting disclosures and certain types of information, and what may be useful about what we're trying to get done at sort of a broader level through the TCFD. And I would say there's sort of three broad categories in which there may be differences that are useful to elucidate. The first is the question of consistency and harmonization. Many companies are obviously listed in the United States and therefore subject to the 33 and 34 Acts and Regulation SK, although many are dealing with, as I mentioned, multiple inconsistent disclosure regimes, both voluntary through NGOs like CDP, which asks for a broad range of climate-related data that goes beyond, in some ways, what the SEC currently asks for, and also in outside of the U.S. in other jurisdictions where they operate. And so the French have a new law that requires a certain specific set of information to be disclosed relating to climate risk. That is inconsistent with, to some degree, and just by design, it's not meant to be coherent with what is in the SEC's current guidance. And so one of the things the TCFD is going to try to do is distill down a set of consistent principles that can be applied across companies, across asset classes, and across jurisdictions. The second thing that most securities regulation, and I believe the SEC mostly has looked at this in this kind of way, most disclosures are backward-looking rather than forward-looking, and there is very little scenario analysis that's requested or required under securities law in terms of thinking about, for instance, a pathway to a 2-degree or 1.5 degree scenario, or doing some sort of 2-degree stress test, as the Wall Street Journal headline indicated, and also as the NGO and advocacy community have been pushing for, at least from fossil fuel companies. And so the sort of time element, the backward-looking and the sort of reporting of climate-related information versus the forward-looking scenario analysis is another area where we hope that the TCFD will provide some useful guideposts for how, to some degree, companies individually, asset managers and asset owners, as well as regulators, can think about future scenario planning. The third, I would say, is scope. And this is where we get into why the Financial Stability Board and the G20 are interested in this, rather than just national securities regulators. There is embedded within a set of asset-level risks the potential for systemic financial system risk that does not is not captured by plain vanilla issuer level disclosures. And so if you think about what the SEC asks for, a universal owner or even a bank, a financial intermediary like JP Morgan may meet the standards that are imposed under Regulation SK or the update that may happen, but that may not tell a macro-prudential regulator like the FSB where there may be systemic risk hidden in the financial system, broadly speaking. And so this is probably the thorniest area where we at the TCFD are grappling with competing viewpoints and inconsistent guidance and a very preliminary set of findings and thinking about what really is systemic about climate risk in the financial system. But both the who, in terms of not just emitters, but sort of asset owners in the financial system overall, and also the what, not just emissions data or regulatory risk, but some of these, I would call them fat tail risks, are areas where we hope the TCFD will provide some useful guidance that, it's beyond the scope of my mandate to say whether or not the SEC might look at that and be informed by it. But those are areas where I think the bleeding edge of this thinking on climate risk is going to evolve over the coming months and probably years.
Thank you. Let me now turn to Christopher Davis of Ceres and start by asking, in your view, how have companies been doing? How have they been performing in carrying out the SEC guidance? Has there been generally good compliance, and has compliance varied across different sectors of the economy?
Well, it's hard to generalize, but in general, not very well. Let me step back for a minute and just share the perspective that I bring and that Ceres brings, which is the perspective of institutional investors, pension funds, endowments, foundations, some family offices, and asset managers. So asset owners and asset managers. And the managers range from, the giants like BlackRock and State Street to some of the smaller socially responsible investment funds, green boutique funds, and so forth. So our investor network is a big tent with 120 institutional investors, and they largely manage the retirement savings of public employees, such as the New York State Common Retirement Fund, the New York City pension funds, what people are going to live on for the 25 or 30 years after they stop working, and the savings and investments, things like college savings of individuals. And these investors are increasingly recognizing that climate risks can have a material adverse effect on the portfolios that they are stewarding for their members and their beneficiaries in their position as investment fiduciaries. So in that context, investors are starting to care more and more about climate change and are scrutinizing the disclosures of companies and asking the SEC to do more. So in general, I'd say corporate climate disclosure in the United States is not very good. It hasn't improved much in the 6 years that I've been a recovering lawyer working on this at Ceres. It's spotty. I'd say there's widespread non-compliance, i.e. failure to disclose material climate risks. Disclosure rates improved somewhat in 2010 after the SEC issued its guidance. and it also issued some comment letters to companies questioning their disclosures, although not a whole lot, maybe, peaked at 20 a year. But still, today, the extent and quality of reporting is mostly poor, with some exceptions that I'll mention, and not very helpful to investors. There's a lot of generic boilerplate disclosure. There can be no assurance that climate change will not adversely affect our business in some way, nor can there be assurance that the sky won't fall or will be struck by lightning. But that's not very helpful to investors. Very few companies quantify the risks. Very few companies talk specifically about which specific climate risks of the type that Dan just mentioned in the three categories affect what aspect of their business, what assets could be affected by rising sea levels or extreme weather if you run power plants or other physical assets. And very, very few companies discuss or attempt to quantify the foreseeable financial impacts, which is what SEC disclosure is all about. It varies by sector. I'd say the energy sector is quite mixed. Electric power companies tend to do the best disclosure. They clearly understand that regulation of greenhouse gas emissions can materially affect their business, and they have the most experience with this type of regulation. Oil and gas companies, I'd say, are the worst of the energy companies. They tend to say something about climate change, but it's mostly boilerplate. And in other energy-intensive manufacturing sectors, autos, steel, cement, and technology, which actually uses a lot of energy for data centers, very little disclosure. And the insurance industry, we've done some reports at series on the insurance industry and their disclosures, doesn't do a very good job at all. And they are, a property and casualty insurer can be the most materially affected. Think of the insured losses in Hurricane Sandy. And by the way, I think it was yesterday's series released a report on the carbon holdings of the insurance industry. How much in terms of oil and gas, coal, and electric power companies that burn coal or gas do they hold? And a surprising amount. So there are risks to that sector that I think they are not really recognizing or disclosing. So, I can give some examples of particular companies that have done well and done poorly. National Grid, which provides electric service in Greater New York as well as in the part of Massachusetts where I live, albeit a British-owned company, which may have something to do with it, does a particularly good job in providing thoughtful, detailed disclosures. And on the other end of the spectrum, Chevron, the subject of one of the votes today, talks only in the most vague and general terms, so that they sort of check the climate box but say very little that talks about how it might affect their company. So there's a lot of room for improvement, and there's a lot of room for the SEC to better enforce their requirements.
Can you say a word about, in your view, what ideal disclosures would look like?
Yes, Siri says a lot about that, and my colleague Jim Coburn is here, who spends his life on or most of it at least, on climate disclosure. So under current rules, under Reg SK, I think a lot more is required and called for. First, the disclosure should be specific, a particularized discussion of climate risks and opportunities with respect to specific company assets and operations, how the company's particular line of business and geographic location is likely to be affected by different types of climate risks, such as policy or regulatory risk, technology or energy transition risk, physical risk, water scarcity, impacts to their supply chain. And climate risk can affect one company different ways. Also, climate opportunities should be disclosed, and that was called for in the SEC guidance. So for a number of companies, for example, in renewable energy or energy efficiency, which can be exploited to advantage by electric power companies, and also oil and gas companies. Some of the European oil majors are starting to diversify, albeit in a small way relatively, into renewable energy businesses to, I guess in essence, hedge their bets on climate change and have a horse in the race if this energy transition accelerates and renewable energy becomes a much more important energy source, which all indications are that it's doing. Also, we believe companies ought to be quantifying their emissions and trends in their emissions and the financial impact of emission regulations or policies in ways that would allow investors who are the primary target of SEC disclosure to make comparisons between companies in a sector or between sectors. That's very difficult now, given how spotty and inconsistent or lacking disclosure is. And finally, we believe that companies in framing their climate risk disclosures, like their other disclosures, should do this from the perspective of investors' needs and interests. Materiality is defined by the SEC and the Supreme Court as turning on the needs of reasonable investors, information they would need to make investment decisions or that would significantly affect could significantly affect those decisions. As the Supreme Court says, the total mix of information that investors should consider. So investor perspective should inform corporate managements and boards' judgments about what should be disclosed. Again, climate risk is a growing concern of investors that we believe are reasonable investors that we work with.
Could you give us your assessment of the SEC's performance in enforcing the guidelines, making sure that companies carry them out?
Not very good. I'm glad Mary Shapiro isn't here because I wouldn't want to insult her for her tenure, and it was better when she was in charge and she was the chair. The SEC has done little, particularly under Chair Mary Jo White's tenure, and goodness knows they have a lot else to do at the SEC and forcing Dodd-Frank and other things. But they have paid, at least there's no evidence that we've seen that they've paid much of any attention to climate change. The flow of comment letters, of which the SEC must send, 10,000 a year, to companies across sectors, across a wide range of issues, has dwindled to zero. So there's nothing coming out of the SEC in the last 2 or 3 years that indicates any interest or any pressure on companies to disclose climate risk, or that the SEC thinks this is an important or a material risk. And that's a problem, because if companies see no adverse consequence to boilerplate or no disclosure, it's a lot easier for them to not talk about this, and this can be a difficult issue for a coal company like Peabody, for a carbon-intensive electric power company, and maybe even for an oil and gas company that's primarily an exploration and production company. It's not diversified. Climate change and regulatory responses to it, and technology transition and consumer responses can pose an existential threat, and that's a hard thing to talk about, and a hard thing for a company to get their general counsel to say that you should disclose candidly to shareholders, because presumably it would not have a positive effect on the share price if one company came out and did that and their competitors didn't. So, but in any event, the SEC is sitting on their hands on this issue.
So if companies did fully comply with the SEC's 2010 guidelines, would that be sufficient? Do you think that would be making the sorts of disclosures that you would call for, or do you think more is required than that?
Well, I think there's a lot of room under the existing Reg SK, which again calls for the disclosure of material risks, to require And would say it does currently require much fuller disclosure by many more companies of climate risk. And if the SEC's interpretive guidance on climate risk, which from the Commission's perspective is an explanation and a guide to companies on what those regulation calls for in the context of climate change, were complied with, we think it would make a big difference in what companies are disclosing and a big difference to investors in the quality and extent of information they're getting. I mean, companies would actually be explaining to investors how climate change affects or is likely to affect their business. They'd have much more comparable information about the impacts and risks from climate that would enable them to make investment decisions and to decide which companies in a sector or which companies across sectors present better or alternatively more risky investments. Another value of climate disclosure is it provides a basis for institutional investors to engage with the companies. A lot of the pension funds we work with, a lot of the large and small asset managers meet with companies in which they have major investments, and they talk with management. Occasionally they talk with the board about the prospects for the business, the material risks that the business faces, its opportunities, and what the company's strategy is. If a company says very little about climate change, it gives investors very little to work with. It may suggest that management just doesn't get it, and that should be a subject of engagement. But we think that it would make a significant difference to investors and also to companies. What gets measured gets managed, and a company that analyzes its risks in a thoughtful and comprehensive manner, and faithfully complies with the requirements to disclose the material risks to shareholders and to the public, and has to have the CEO and the CFO sign off on those disclosures under Dodd-Frank, is presumably going to pay much better attention to managing those risks, to actually having a strategy for energy transition and the growing incidence of greenhouse gas regulation, and to be looking at what opportunities it can identify over its competitors, for example, in responding to climate change and investing in and offering products and solutions in the nature on climate solutions. So yeah, we think it would be a big deal if the existing Reg SK were complied with.
So my final question of you right now is, what's your perspective on the SEC concept release that they issued last month, and can you give us a preview of what Ceres is going to be saying in response?
Sure. So we think that the concept release is both a big deal and significant, but don't have our hopes up really high that there will be major consequences, or at least we've suspended our judgment in sort of a wait-and-see manner. So it's very positive and unprecedented that the SEC has asked specific questions, 4 or 5 of them, about climate and sustainability, what we call ESG, environmental, social, and governance risks, and the extent to which the existing disclosure rules are adequate in providing the information that investors need there. It's a great opportunity. SEC Commissioner Stein, one of 3 sitting commissioners, and it's sort of a problem that we don't have a full complement of commissioners. 2 of the seats are currently vacant, and the Senate doesn't seem to be in any hurry to confirm the other commissioners. But I think Commissioner Stein, in some recent comments, has really, is a commissioner who really cares about these issues, and has encouraged, a lot of response by investors and by other stakeholders who care about corporate disclosure of environmental, social, and governance risks. So we are definitely going to respond. And the investors that we work with, a group of them that Jim has helped organize and support, is working on a set of comments. I think the SEC will be a lot more interested in what investors who invest in companies and act on disclosures have to say, frankly, than what Ceres or any other NGO says. So, but we are going to work with the investors in our network to provide a robust and fairly detailed response, as well as, in all likelihood, sort of a short summary letter that makes the key points, demonstrating that investors, in fact, do care about climate disclosure, about sustainability disclosure, and urging the SEC to actually treat this as a material issue, show that they care about it, and push companies to do better disclosure. Some of the issues that, again, the investor response we expect will focus on is first, and in calls with investors about the concept release, they made this point that really, if companies complied with Reg SK, climate risks are no different than other business risks. They're somewhat misleadingly often called extra financial risks, but if they're financially material, then they need to be and should be disclosed in the same way that any other financially material risk to a business. A competitive risk, foreign currency fluctuations, whether the Federal Reserve raises interest rates, the sort of, quote, financial risks that get a whole lot of attention. We will focus on, a group of, we expect the investors will focus on, a group of particular sustainability issues, including climate change, including water scarcity, that really need much more detailed treatment in financial disclosures. We will call on the SEC, or the investors we expect will call on the SEC, to enforce the current rules. I mean, basically to kind of do their job. So, I mean, the first thing, we also think that there are a number of additional rules and guidelines that the SEC ought to issue, and will make some recommendations that way. But actually enforcing the current requirements and enforcing the guidance and urging companies through comment letters to follow that guidance is important. We will urge the SEC to ask companies, as investors have been doing in the shareholder proposals that were just received strong votes at Exxon and Chevron, to do 2-degree stress tests. In other words, to test their business strategies and business plans against a set of policies that would limit greenhouse gas emissions so that we didn't have more than 2 degrees of average warming. In other words, if the Paris Agreement were implemented, this is no longer a fanciful scenario. The 195 governments agreed that the world would move to decarbonize the economy, that governments would implement national climate plans that would bring us to a 2-degree or limit warming to well less than 2 degrees with an aspirational goal of 1.5 degrees. So, this is now becoming sort of a baseline that companies have to take seriously and need to compare their business strategies to. And we will ask the SEC to, get companies to produce comparable data in sectors that voluntary reporting doesn't provide right now. So I think we and a lot of investors have indicated interest. We think they'll get a lot of feedback. I expect that they'll probably get pushback from the Chamber of Commerce and those who say that there'll be some adverse consequence from asking companies to make more disclosure, and we think the SEC is likely to get a lot of comments on this. But it's great that they've asked.
Thank you. Let me now turn to Professor Fox, and I'll start by asking Can you tell us a little bit about the history of SEC action in mandating disclosures of issues of social concern?
Sure. It really goes back more than half a century. We can kind of tick off a variety of areas over time. So probably starting with concern about foreign corrupt payments in the 1960s. Before the Foreign Corrupt Payments Act, the SEC, as it became apparent through some investigations that came out of the Watergate scandal, that U.S. companies were paying bribes abroad that were contrary to our concept of how our companies ought to operate, began to require specific disclosures in this area. And then in the 1970s, as the environment came to the forefront as a major social issue, the SEC enunciated a number of specific environmental requirements. In the 1990s, executive pay it's echoing again, but it was sort of first bubbled up, and the SEC inserted a whole new section of ordinary disclosure concerning executive pay. And then most recently, what we've been talking about today with the 2010 climate change guidance release, which clearly reflected concern there. So I think the big question, if we look at this history, with what these requirements are about, one view is it's just about helping investors better predict the cash flows of these companies in the future, give them more information so that they can make more intelligent buy, sell, or hold decisions as investors and make more informed voting decisions with their proxies. On the other hand, maybe there's something more here, some kind of additional spotlight function to kind of get companies to behave differently. If they have to talk about something, wholly aside from their share value maximizing decisions, they may be kind of shamed into behaving differently. Now, the SEC has kind of wavered a bit as to what it says is motivating these kinds of new disclosure requirements, but generally it's insisted, no, we're just trying to inform investors with the information that's important for them to make investment decisions relating to cash flows in the future. But if you think about the background against which each of these initiatives developed, and sort of the main groups that were pressuring the SEC to take initiatives, and we've heard lots of discussion tonight, and which tended to be sort of public oriented advocacy groups, government, investors that have some kind of government relationship, like state pension funds, other endowments of nonprofits that have certain social concerns. Those have been really the pressures typically on the SEC. So while the SEC says usually we're just doing this so that investors can guide capital to the place it best ought to go and so on, sometimes their rationales for that, I think, are a little bit of a stretch. I do think there's an element of spotlight or shaming function there. And I think it's telling, for example, the 2010 guidance was passed by a 3-2 vote by the SEC. It was very controversial. even though, as I think we'll discuss, in some ways it simply told companies to do what the rules already said they were supposed to do.
Is there anything more you'd like to say about how either that 2010 guidance or the 2016 concept release fit into this overall picture?
Sure. The 2010 guidance, it was a so-called interpretive guidance. So in other words, the rules regulation SK rules, sort of the form in some sense, the set of questions you have to answer, didn't change. Instead, it just kind of gave a gloss to those rules. And they, so in essence, pointed out the existence of a number of rules where they thought that either the possibility of new regulations, environmental regulations, could affect the business future of the company, or climate change itself could affect the business of the company. So, for example, one of the items is, you have to comply. You have to indicate if there's a material cost complying with environmental rules. You have to talk about pending legal proceedings, including environmental laws. You have to talk about material risk factors. Maybe most importantly is the so-called management's discussion and analysis section of Regulation SK, which requires companies to identify, quote, known trends, events, demands, and commitments and uncertainties that are reasonably likely to have a material effect. And the SEC has a scheme for how you're supposed to prepare this, in essence, future-looking part of the disclosure package. Basically, look out and see if there's any kinds of uncertainties that could have a material effect. And if you can't determine that it's unlikely they're going to happen, but if it happens, it would have a material effect on the company, you're supposed to disclose it. Now, nothing in this release, therefore, kind of formally changed any of the requirements imposed on companies. But the fact that the SEC came out with the guidance suggested, for example, to disclosure lawyers, that the SEC was expecting more robust disclosure in these areas. If you're filing a registration statement or something, particularly in an IPO, the SEC always comments on the first draft, the first filing, and so on. This would be a suggestion that the SEC is going to take a harder look at these matters. It's true that the SEC has not filed any actions concerning climate-related disclosure issues since the 2010 release. In other words, they haven't taken formal action. I think it's harder to know what kinds of informal actions it's taken in reviewing filings. I think, as a general matter, securities lawyers pay attention to these guidances, and that in turn affects the disclosure behavior of companies. Now, the 2016 concept release is different, I think, in some important ways. First of all, it's much more kind of expansive, and it's more let's try and think outside the box. But it's at the same time, it's largely phrased in terms of asking questions, but it suggests the SEC wants to think more broadly about these issues than what has been required so far. So you might ask, well, why is anything more necessary? And Daniel and Christopher have already, I think, talked some about those questions. In essence, why would you require more specific questions when, I've kind of described already, you're supposed to describe material risks. You're supposed to, if there are uncertainties that could have material impact on your company, discuss what that impact would be. Why do you need more? Well, one thing I think is if you have what securities lawyers call line item disclosure, very specific questions about things, it's easier to tell whether there's compliance or not. It's hard to know if it says disclose all material risks and you list 1, 2, and 3, and you don't say anything about the environment. It's hard to know whether there's a material risk associated with climate change or not. And same thing for the management's discussion and analysis, where certain uncertainties or trends, and could they have a material effect. It's particularly hard. You don't really know whether those exist or not until something bad happens. And one of the problems with environmental disclosure about environmental issues is that something bad might be 5 or 10 years off, not in the next quarter or the next year. So enforcement's difficult. And then another point, which Daniel and Christopher, I think, both raised as well, is it's difficult sometimes to make an overall evaluation of companies in general. If every company gave you more information about certain things, you'd know more about each company. Information that if just one company gave it to you, you wouldn't know that much more about them. But if you begin to have some understanding of carbon contribution from the wide range of companies, it really would help you understand much more. Then beyond that, I think this is one of the great debates in some sense, is probably, I'm sorry to say it in this group, probably the vast majority of investors are not, quote, ethical investors. They're investing to get the highest return. But we know there are ethical investors out there. They're not insignificant. Information for their purposes can be important as well. One thing I ought to say, though, about the concept release that we ought to keep in mind is it's a product of a congressional mandate to make disclosure less burdensome. So you have to, if the SEC is if the basic complaint has been, look, you've just been adding rule after rule to Regulation SK over decades, and you never take rules out, you just add more requirements.
Can I just ask you to say a word about that congressional mandate, when it was enacted and so forth?
It came out of the either the Jobs Act or the FAST Act. I can't now remember which.
Okay, but it's very recent.
Fairly recent, yes.
Okay. Can you tell us a little bit more about the Martin Act and what sort of penalties and remedies can be imposed under the Martin Act and what procedures would be involved?
Sure, and maybe I'll just come up to the podium for a moment if you don't mind.
How do we find it?
It's down underneath. If they have a clicker, I can step, otherwise I'll...
There we go. That work?
Yeah, okay, so Lemuel's already, I think, talked a little about it, but the Martin Act is an extremely broad act relating to the purchase or sale of securities. So it basically allows the Attorney General of the state of New York to bring civil or criminal actions against a person who undertakes, quote, any fraud, deception, concealment, suppression, or false pretense in order to, quote, induce or promote the issuance, distribution, exchange, sale, or negotiation or purchase of a security. And maybe the most important aspect of this provision in the Martin Act is, unlike federal securities laws, the Attorney General doesn't have to prove scienter. You don't have to prove that it's a knowing fraud and an intention to mislead people. The other component of the Martin Act that is very relevant to many things that Attorney General Schneiderman and his two predecessors have done is the Act authorizes the Attorney General to commence investigations with very substantial discovery powers, including being able to issue subpoenas without court order, which is an unusual kind of provision in the sense of allowing the potential prosecutor to be able to engage in that kind of discovery without court approval. And in that regard, if just to kind of flesh out the Martin Act a little bit, let me just give my own reactions to, and Lemuel may want to say some things in reply, but my own reactions to the ExxonMobil investigation. So the ExxonMobil investigation, as we understand it from the press releases from the Attorney General's office, relates to a couple of kinds of concerns. One is that ExxonMobil, over a period of decades, made statements about global warming that were contrary or not fully consistent with things that some of its own scientists who were doing climate change work were saying inside the company, and also that the company had funded advocacy groups, research and advocacy groups that tended to take climate change skeptical positions. I think, remember what the Martin Act requires. It requires something of deception or fraud. And the New York Court of Appeals has said, and I don't think this is a big surprise, that in essence, charges of fraud under the Martin Act have to be, quote, material. In other words, it doesn't deal with every misstatement or omission, only with material statements and omissions. And the New York courts have adopted a definition of materiality that's very similar to the federal law standard. Basically, the substantial likelihood a reasonable investor would consider important in deciding how to vote or to buy, sell, or hold, and that it has to significantly alter the total mix of information available to this sort of reasonable man, the reasonable investor. I think the big question here is, if the public had known what the Exxon scientists were reporting internally, would that have changed the total mix of information available to investors in their decision as to whether to buy, sell, or hold Exxon stock? I guess I'm pretty skeptical. The market was well supplied with information about climate change from a variety of sources. There's nothing, I don't know what the documents will discover, but I'd be kind of amazed if what the Exxon scientists knew was so different than what other scientists outside Exxon knew and were, and whose views were publicly available, that it would change that total mix in a significant way. And in that regard, I think this is very different than what I understand were the facts with Peabody and the settlement that was reached there. This was not a statement about climate change. It was a statement about the effects of climate change on Peabody's business. Peabody had said in its 10K it couldn't predict the impact of restrictions on the burning of coal on its bottom line, when in fact, as Lemuel has told us, it had internal it had done internal studies with quite specific kinds of predictions. What bothers me here, and believe me, I think climate change is the probably the issue of our time. But what bothers me is the use of the Martin Act and the state attorney general. And remember that 2 out of the last 3 attorney generals have become governor of the state of New York, using this kind of investigatory power in a case that to me seems so unlikely to be ultimately, if it was ever taken to court, to be a winner. I think Lemuel's statements about our concern about global warming are right on point. But that's not what the Martin Act is about. The Martin Act is about investors who are defrauded. And we've got a system in which the Attorney General has a great deal of power, a very unusual amount of power, and the typical pace of things is an investigation starts, and then there's a settlement. We never see a complaint. We never see an articulation of the facts and how the theory of the legal case is as to how the law relates to those facts. We simply have an investigation and then agreement that's posed in the form of a cessation of investigation. And so I'm certainly concerned about Exxon's role in our future, but I wonder about the use of the Martin Act in it.
Lem, do you want to say anything in response, or?
Sure.
I just thought you'd want a little entertainment. Yeah. Sorry to be the skunk in the garden party.
Oh, Professor, that's all good. I mean, you've raised some important legal points, prudential points here, but what I would say, again, you know, what I related before is this investigation isn't about the truth of climate change scientists, either inside Exxon, outside Exxon. It's about how this company looked at an issue, analyzed that issue, the actions it took internally and externally around those risks, and was that compliant with our New York state laws, or was it not? That's the nature of the investigation. The Martin Act is a tool available under New York law. We use it all the time, day in and day out, in a whole range of investigations. And my conversation, the point about climate change impacts in New York today is not to say this is about social factors that mesh with a legal tool, but rather to say that it's very clear that risk driven by climate change to companies, particularly fossil fuel companies, is an issue that is important to investors, to consumers, and all companies, large and small, must comply with our laws that address those issues for our markets.
So I guess I wonder basically whether the Martin Act is the right tool here, because I think we could imagine other tools, including what the vote was about today in Texas at the ExxonMobil shareholders meeting. Where the shareholder resolution, which if it didn't pass, at least it received a moral victory, a very, very high vote for this kind of a proposition, the kind of thing that tends to push management, asked for more specific disclosure about, well, you know, if there are restrictions on increasing restrictions on the burning of fossil fuels, how are you going to run your business in the future? That seems to me to be a more promising way of dealing with this kind of problem. I spent 4 years as chair of Columbia's socially responsible investing committee. And one of the issues that we were frequently confronted with were these kinds of more sort of social issue-oriented shareholder propositions. And it always seemed to me that one of the functions, and I think it would be a useful one here, is kind of a consciousness-raising function. You know, generally we entrust management of business to try. They have plenty of pressures to try and figure out how to run their business in a sensible way for both the shorter and longer run. But sometimes they get lost in their own belief systems, and these kinds of resolutions and what they call for can be helpful.
Can I ask you, Professor Fox, whether, in addition to the shareholder resolutions, are there other legal tools that might be available to investors or other persons who are concerned about these disclosures? Are there private actions or other things that can be taken?
Well, certainly in theory there are. Now remember that if we were talking about the federal securities law and a lawsuit under the federal securities law, someone would have to prove not only that the company made a material misstatement, but that it did it with scienter, that it did it knowingly, which can be quite tricky from a proof point of view, and that finally that there was so-called loss causation, that in essence, when the truth came out, basically, that the misstatement made me pay too much for these securities, typically demonstrated by when the truth came out, the price of the stock dropped. So, in theory, if one could demonstrate that there was some kind of material obfuscation about something related to climate change, that when the truth came out, the stock price dropped significantly. Everybody who purchased shares while the price was inflated by the misstatement would have a cause of action for damages against the company and could pursue that in a class action.
Dan or Chris, is there anything you'd like to add at this point?
I guess one point, going back to something Professor Fox said, is I think that many people, for some investors, there's a distinction between investing to cure social ills or as you know, many religious investors have done over time. But the investors we work with are overwhelmingly, fiduciaries. Comptroller DiNapoli, who's the sole trustee of the New York State Common Retirement Fund, managing nearly $185 billion in retirement savings, and by law they are compelled to invest and to take actions that are in the best interests of their beneficiaries in the long and short term. Those who are retired now and collecting their pensions, and those who will retire in 30 years. And it is from that perspective, certainly in their minds, that they take actions from filing, range from filing the shareholder resolution with Exxon that was co-filed by the New York State Comptroller on behalf of the State Pension Fund and the Church of England, as far as interesting bedfellows. I believe that the trustees of the Church of England Pension Fund would also say they're investing as fiduciaries, not with their first priority being to save the planet, although they would surely also say they're an ethical investor, but also in order to reasonably maximize their return so they can pay the pensions of their clergy. And I think a lot of these disclosure issues, at least from our perspective, and again the investors we work with, come up in a fiduciary investment context. I mean, those of us at Ceres are motivated by doing what we can to halt climate change, and it's one of the things that keeps us coming to work each day. But in order to be successful in doing that, I think we have to succeed with the economic and the financial arguments and the business case that these companies are better if they manage these risks and disclose them and disclose what they're doing about them than if they keep their head in the sand and don't.
We have time for questions. And I would ask that if you have a question, if I call on you, there's a button in front of you, please hit the button so that it activates your microphone.
Thank you all for your presentations and for this dialogue. It's been really informative and wonderful. I'm going to ask sort of a legal-ish question, which any of the lawyers and law-trained practitioners at the table might answer. Obviously, materiality is tied to this idea of the reasonable investor. And I'm wondering if you just talk a bit about what that reasonable investor looks like today. Are we talking about a high-speed derivatives trader or a high-speed trader whose information about long-range risk is fundamentally irrelevant? Or are we talking about pensions and other institutional investors? And is it different? And if there is a key difference between what is reasonable to different types of investors, how does that influence what the courts might have to say about this should it ever make its way into court?
Yeah, of course, the reasonable investor is, an abstraction in a judge's mind, I guess. But I think most securities lawyers and securities law scholars look at the question of what's important to a reasonable investor is, in essence, what is information that would be likely to change the price of the security by more than a de minimis amount when it becomes public? Most finance economists think that markets are efficient, that when information is clearly made to the market, if it seems to have predictive power about the long run and short run future cash flows of the company, that will be reflected in price. And I think that's sort of the general concept of materiality. Now, it may be that in many instances, that determination ultimately comes out as a judge says, well, does this look like it would be important to me? In other kinds of cases, you actually have to sort of prove materiality by proving a stock price change when the information comes out.
A quick comment on that. I think it's a hard question, and part of it is the time horizon of the investor. Ann Simpson from CalPERS, the California Public Employees Retirement System, that our biggest pension fund, and she's the head of corporate governance, often says there are three kinds of investors. There are traders, raters, and owners. And we tend to work with those who are owners, who own the companies for a long time. If you're a day trader or trying to, figure out, short-term fluctuations in the stock price, then, I'm guessing climate risk is probably not material to you. If you are a long-term owner who's going to own Exxon in 10 years, partly because you're a passive index investor, which a lot of the pension funds are, so they kind of own the market. They own the S&P 500 or the Russell 1000 or the FTSE 100, and they will own them, in many cases, 10, 20, 30 years from now. So, certainly these climate risk is material to a long-term investor who's a buy and hold, or ought to be material to Warren Buffett, since he finds good companies and buys them and holds them forever.
Thank you, all of you. This is wonderful. My question is, in this particular case, the omitted fact relates not only to the individual investor in the total mix, but it relates to the total body of knowledge, therefore affecting the court of public opinion, and potentially had delayed taking action on this serious problem. And there is a residual effect of not only omitting the fact, but putting out misfacts that still linger today in the minds of some, also causing delay in taking action. So although this is particularly related to the Martin Act, it seems to me that the implication goes far beyond the individual investor. And I have a second question related of Daniel Farber and relating to transition. If you could say a word about the transition. Is the concern with megawatts, terawatts, the specific type of offshore wind or whatever, or is it in relation to having to establish new manufacturing, for example, wind turbine blades, cable, and the ships to install and maintain them? So two questions, if there's time.
Anybody want to?
Well, I can take the second question. I'll leave the first to perhaps Lem. I think what Governor Carney means when he talks about transition risk in the context of the transition to a 2-degree world, we kind of, in the climate wonky community, talk about that quite a lot, is that there is a smooth and a bumpy path to get to a low-carbon future. The smooth would entail a company like ExxonMobil, transforming its business operations over the course of the next several decades to do more than just buy and, discover and refine and sell oil and gas. The bumpy is where a company like Peabody finds itself in Chapter 11, having not thought about or not being willing to publicly acknowledge that the market for coal, at least in the United States power generating market where its biggest customers were, was not going to necessarily be there the way it had been in the past. And so one of the things I didn't mention earlier, which is important to kind of acknowledge with regard to what we're doing at the task force, is there are both climate risks and climate opportunities for new businesses to innovate and also for existing companies to evolve over the course of the coming years. And I would say that transition risk is only a risk if it's not something that's appreciated and dealt with by management.
Thank you.
So as to I think the first part of that question, or the first question, relating to far beyond individual investors, I think that ties in a bit to Professor Merritt's question was, is the Martin Act the right tool in a particular circumstance? And I think the answer to both is that the Martin Act is one tool. It provides a particular set of legal protections to investors in New York. It's not the only tool that we are looking at conduct under, and those other tools look at consumers, look at broader protections to New Yorkers under our general business law.
Thank you.
Can I try a brief
Yeah.
perspective on the first question, which is a hard one? I guess to the extent that the companies or their trade associations have been or were sowing misinformation about climate change, it's not a risk, it's a hoax or whatever, I guess that can have two effects, basically sort of manipulating the policy risk by making the public voters less likely to demand action on climate change. And I think that's in effect happened, so that they've sort of postponed the implementation of policy action that will bring to bear, bring some of these risks to fruition. It also may exacerbate the risk that when things get really ugly with climate change, there's a hypothesis that policymakers will act rapidly and drastically to cut greenhouse gas emissions, and once they realize the catastrophe is looming, too late. So I'm not exactly quite sure what the implications of that are for climate disclosure, other than kind of hiding the ball has a lot of pernicious consequences.
Thank you.
Hi. So I have two quick questions. The first one is, to what extent, especially after the Peabody settlement and some of the New York work, to what extent can companies run internal scenarios and not be worried that they may be subpoenaed or subject to disclosure? And could this have a chilling effect on companies being able to run different scenarios? Do they have to assign probabilities to them? And would those numbers indicate whether it's material? And would you be concerned about some kind of a chilling effect? And then the second question is, to me, one of the most problematic parts of the SEC guidance is the physical risks of climate change. The science is really clear on like average temperatures and sea level rise and even heat waves, but when you talk about other types of physical risks from climate change, especially downscaled to the kind of levels that would really impact a company, like where they have particular supply chains or whether they have facilities, it's much more difficult for a company to say, well, the water is going to be more scarce in this particular source that where we get our water. And so I just would like some of your comments on what you think about those kind of physical risks where the science is really, when you're talking about downscaling it to that kind of level, is really may not be there.
Let me say something to the first. I actually think that may be an area in which I think what you're saying is always a concern, that when you that if you say, tell us what you know, you're going to try and know less bad things, which may be another rationale for more specific line item kinds of disclosure, because then in essence it's requiring you to do that kind of study.
Two comments. First, I think any prudent company that is at least in a carbon intensive or energy intensive business and probably beyond, you really ought to be doing, after the Paris Agreement, at least 2-degree scenario analysis just to prudently manage their business. And the securities laws, if that identifies a material risk, then you need to disclose it. A lot of companies have said that, sure, we do these analyses, but we're not going to disclose them because it's confidential business information, be prejudicial to our company and our competitive position. I think that proves too much, and everyone needs to comply with the law. I had something to say about your second question, but I don't remember it.
I'll take a stab at that. I didn't mention this earlier, but another project of ours is something called the Risky Business Project, which Mike Bloomberg launched in 2014 with former Secretary of the Treasury Hank Paulson and Tom Steyer, a left coast climate activist and former hedge fund manager. And that project was designed explicitly. Times have changed, and it's 2 years later, and we're all much more sophisticated than we were in 2014. But at the time, the economic and specific asset level and even, census tract level climate risk profile on heat, drought, water availability, sea level rise, agricultural productivity, those were data sets that really just did not exist. And I would say you're right that asset level attribution to global average surface temperatures when you're talking about water availability is hard, but it's actually, of the three risks I outlined earlier, the easiest of the three, and there's quite a lot of room for companies to improve from where they are today to where the state of the science is and the econometric analysis that is available now regarding very specific asset level climate risk on the physical side.
Let me just add one thing about that. It is certainly very difficult to predict what will happen at a particular place, but we now have much better information about probabilities. And so if we are looking at a $1 billion facility, we now may be able to say that within the next 20 years, there is a 10% chance that it will be underwater and be destroyed. And so if you have that kind of probabilistic information, companies can then make judgments about whether that's material and what precautions they need to take.
I remember what I was going to say about that. First, the MD&A, as Professor Fox pointed out, requires you to talk about known trends and uncertainties. And even though you can't predict exactly when it will happen or how severe the drought will be, a number of these climate change effects, I think, are known trends or known uncertainties, whatever that means, and that it's something that companies need to be analyzing and disclosing to their shareholders.
Final question.
I was wondering what you think the reporting to the UN Global Compact, companies having to discuss their sustainability obligations, what they're doing, how it affects the legal aspects that you have been discussing, because companies pay a lot of money to follow through in the Global Compact, and maybe this is assuaging some of their guilt.
I have a perspective, and there's a wide range of, in many cases, pretty good disclosure through the UN Global Compact, through CDP, through a lot of the voluntary disclosure regimes. When you read a lot of them, you think, well, there's some material risks here to this company, yet you read their 10Ks, their SEC filings, and there's often silence or this generic boilerplate. I almost think that for a lot of companies, those who do the CDP reports, who tend to be in the environmental division or the sustainability director or something, don't talk to. And in fact, in a lot of companies, we've been told that they don't talk to the CFO or the corporate secretary or the treasurer, let alone the CFO. So I think it's both probably a legal problem and a liability that companies have painted a pretty full picture in many cases in their voluntary disclosures of what some of these risks are and how they will affect their business, and in some cases what they're doing about it, and then maybe a fruitful source of information for securities plaintiffs who want to point out that disparity. The standards are clearly different in terms of materiality, but there's a problem there.
Please join me in thanking Lem Srolovic, Merritt Fox, Dan Firger, and Chris Davis.